Here's the question I'd like to, by way of introduction to what we have today on the last of the three branches of government dealing with now the judiciary, is to ask you, and see what's on your radar now, regarding this branch of government, the judiciary. Do you think that do you think it's proper that we all sort of sit and wait to see what the Supreme Court of the United States says on an issue about whether it's going to be something that's permissible or not permissible? First of all, do you think that that's the general mood of the country? Do you find that problematic? I don't know how else to sort of ask this. So talk to me. What do you think about it? Is the Supreme Court sort of the final word on things for the country in matters that sort of impact us all? Have you ever thought about that? Yeah? You don't think it should be. Now, if you don't, then you're going to have to generate some kind of argument to the culture about why. And you may not have that right now. That's fine. So there might be some kind of, you might embrace my question and go, well, maybe it is, but I don't think it ought to be. And I'm not sure why, but I sort of don't like that. Okay, fair enough. Anybody else? Any thoughts on that? Have you ever thought about it? Do you have a problem? I mean, we talk about, and some of you got a chance to read some very notable court cases in our class here this semester. And some of those have seemingly settled big issues of national importance, like Roe versus Wade deals with, you've heard that one, right? Abortion. And in that particular case, the guy who wrote that opinion, a justice named Blackmun, was shocked that there were some pro-life people out there that didn't sort of get the message and just sort of put this thing to bed. In other words, he saw the court as sort of settling this abortion question in favor of its legality, and that those of us who are interested in pro-life affairs sort of should move to another topic because that one's sort of been settled. How about this one? It's 1857, 1858, and the United States Supreme Court saw themselves as kind of settling the slavery issue, largely in favor of the South. And that was a famous case called the Dred Scott case, if you've never encountered that one. So do you think the Supreme Court of the United States should be the branch of government that decides these great issues of national importance? It's sort of like the final word. Maybe you've never even thought about that. I'd like you to think about that today as we walk through this. Good morning. Okay. Yeah, Asma?
Since I like the idea of our Supreme Court being a lot older and not, like the legislation they switch out over years, and then it just
Okay.
sways back with opinion.
Okay.
The judiciary, because it's like more consistent, more constant. There's like a better view on the issues.
Okay, well good. That is an interesting point that we need to talk about. Legislatures come and go. Essentially, the House of Representatives has the potential every 2 years, you might know, to turn over. Not so with the court. Those folks are pretty old themselves, 50s and 60s and 70s, and even one guy recently retired in his 80s. So that, maybe there's some wisdom there. Yes, ma'am.
I think that's a lot of power.
Huh?
I think that's a lot of power for just like a group of people.
Yeah, it is. Should we, and here's just a rhetorical question to your point, should we allow 5 people, because that's all it takes to form a majority opinion on the court. There's 9 justices on the court. Should we allow 5 people on some court to overturn the popular will of the people, maybe as expressed through the representatives? The president, our current president, came out rather controversially within the last month, and essentially argued that this is almost word for word of what the president said, 9 unelected judges do not possess the power to overturn a piece of legislation that was passed in a majority sense by the Congress. That was seen as pretty controversial, particularly by a president who had taught con law at one point in his life, constitutional law. He's since backtracked on that statement because that was quite contrary to about 234 years of constitutional history. And it was interesting, people were all over the map pulling out their hair about why would the president make this kind of comment. The piece of legislation that he was referring to in this particular case was his signature piece of legislation that was passed during his first 2 years in office called Obamacare. So his claim was that the Supreme Court should be hands-off on that, or at least initially he made such a claim. But to your point, that is a lot of power, right? I mean, here's another one. I mean, we sort of talking about the Supreme Court. We have a district court a federal district court that meets in San Francisco. It's called the Ninth Circuit Court of Appeals. And they had one judge on that Ninth Circuit Court. Was it the California Supreme Court? It might have been the California State Supreme Court, but that doesn't matter. It's a court who overturned Prop 8 or who declared it unconstitutional. Proposition 8 was a proposition that the people of California voted on 3-4 years ago to define marriage in the California Constitution heterosexually and that only, and by implication that gay marriage would not be legalized as marriage in the state. And one judge, who himself happened to be a gay man, declared it unconstitutional. That's a lot of power. I mean, millions of people voted on that proposition, yeah.
This could be like uninformed, biased, and not without its problems, but I think it's interesting and kind of stupid that we put, we leave it up to our government to make moral decisions for us. Mm. And that's where my problem lies, is they're now forcing something, well I mean, that's not a good example of it, but like allowing abortion in some respects is forcing a moral value that I don't hold to. Yes, I can abstain from that, but they're supposed to be representing me as well. And so you have two sides of this, and they're trying to make a moral judgment for these two people, and they can't, because you have those without the morals that I hold.
Okay. Well, interesting, isn't it? Well, if it's proper within the sphere of governance, and this is really the hook for me, for you in this course, is what I've been trying to sort of beat the drum on all semester, is that these questions are really important because they're, for most all of us who are American citizens, this is on the table. And for even those of you who aren't American citizens, it's on the table in whatever country you're a citizen of. But now the question is, should the government be making decisions that sort of that affect social policy or that have moral implications? Abortion certainly has that implication. If the answer to that question is yes, then the question is, what branch of government is most proper to make those sort of calls and what's called public policy decisions? Should it be the legislative branch, sort of the popularly elected people that represent us in various legislatures, you know, Congress or state legislatures, or should it be these guys? Let me tell you what Lincoln had to say on the issue before you think about what you might think about it. And you might just be today trying to form your views on this, and that's valuable stuff. I had a young lady in my office yesterday that was wrestling with different views on various and sundry things. And she was frustrated by the fact that she wasn't landing on it. The girl's like 19. That's okay. I'm pushing 50, and in some instances and some views, I'm just really starting to have the concrete harden. And I think it's perfectly okay for you at this particular time in your age and your life, and particularly the time that you're transitioning away from your parents, to really wrestle with things theologically, your political views. Those two questions, I think, are not divorced from one another. I don't think those are two separate questions. I think there's a high degree of integration that you ought to think about. I didn't even think about politics and political views until I became a believer. I mean, that just wasn't even a question that was of interest to me. So I think that of all people, we bring something essential to the political project, is that we have a moral bearing. Because to this question of abortion or any other issue that is laced with moral implications, it might be the fact that the whole project of politics can't be divorced from the moral question. The whole project of politics might itself be a moral enterprise. I invite you to consider, you know, you're going to encounter some point, if you've not encountered it already, somebody making this statement to you. You cannot legislate morality. And there's a point to that. I mean, it would be foolish to try to have laws prohibiting gluttony or lust, right? I mean, in that sense, I think there's a point to that. It doesn't make any sense to try to have laws that would throw somebody in jail for eating too much at Bob's Big Boy tonight, or, you know, whatever. But in a certain sense, that's false. That statement is false, because somebody's view of morality will, in fact, be instantiated in legislation. The question is whose? And perhaps many of the things that I or you may lament in terms of where our culture sort of headed in law is a reflection of the fact that a version of morality that you may not buy into has gained the force of legislation and law, which is a really interesting thing that I showed you last week, you know, with that Amazing Grace. That was why I showed it to you, because those people were inviting Wilberforce to consider that he could do God's work within the political field, because under the British Empire at that particular point in time, something that was grossly immoral was being allowed as lawful, and they were inviting him to a game that he invested his life in eventually to change that. So Lincoln, weighing in on this issue of who it should be the courts or the legislative body as expression of the people, sort of deal with these issues, just a prelude for our time here in the judiciary, said this. And this is in his first inaugural address, and you would have read this and maybe you just went right by you, so I wanted to return to it. Now, Lincoln is referring back here to the Dred Scott decision, in which the court largely sided with the South and declared that the slavery issue was simply a state's issue, and however states want to deal with it, they can deal with it. It's beyond federal power to deal with the issue of slavery. Essentially what the Dred Scott issue decided. Not to mention the fact that they declared a black man not a person, but notwithstanding that. So here's Lincoln's comments on the Dred Scott case and the nature of this, which we're about to turn to now. He says, at the same time, the candid citizen must confess that if the policy of the government upon vital questions which affect the whole people is to be irrevocably fixed by decisions of the Supreme Court, he says the people will have ceased to be their own rulers, having to that extent resigned their government into the hands of that eminent tribunal. You see what he's arguing? He's saying that it was Lincoln's view, and I could read you Franklin Delano Roosevelt and other presidents of this express the same sentiment. If we allow the Supreme Court of the United States to be the final sort of word on issues that affect the whole nation, then we have resigned our liberties to an unelected group of folks. And I don't want to paint too dim a picture of the judiciary. There's a proper role for the judiciary. What I'm inviting you to consider today, and I'm going to tell you a little evolutionary story, is that the court has changed quite a bit since its foundation to what we find it in today. You live today, and I invite you to think about becoming more informed about whether the court is doing what it's supposed to be doing. Is the court supposed to make public policy, make law? I mean, just sort of a high school understanding of what the judicial branch is supposed to do would indicate that they're supposed to interpret the law, not make it. Guess what? They'll give speeches. Current members of the U.S. Supreme Court today will give speeches at law school and openly admit that they make public policy from the bench, and it doesn't seem to be a problem for them. What's happened in 200 years? We might investigate today. All right, so with that as a prelude and hopefully hooking your attention, let's look at the judiciary. And essentially, I just want to do something very basic today. I want to give you a sense of what the original court and the original foundation of the court was supposed to look like. And then the bookend is where it looks today, and tell you just a brief story. And to a certain extent, you'll feel like you're drinking out of a fire hydrant, and that's okay. But I want to just give you a sense of a movement from a very limited form of what's called judicial review to a very expansive, aggressive form of it today. Now, some people celebrate this. You might, at the end of the day, come to the conclusion, or at least the initial, I like what the court's doing today. I have folks that I interact with who say, of course the court is doing something different than what it would have done 200 years ago. But these are modern times, and modern times call for the different branches of government to do different things. And so they have no problem with the court doing this. So, and then others say, this is horrible. Whatever happened to the separation of powers? Whatever happened to the definition of what a judicial branch is supposed to do? Okay, have I hooked you? All right. So here's what we'll attempt to do today. And experience has shown us that we can sort of ease through this today and get through it, but it's a big story, so we'll take our time through it. We'll begin to understand my hook to you today. Why is it that branch of government is seen as controversial? It's seen as, presidency is somewhat controversial. To be honest, the legislative branch is kind of a snoozer, right? I had a guy in my office yesterday wondering if he was going to take a class on the legislation. It's a political science student, and he was like, should I take this class on legislation? I said, are you interested in the legislature? Are you interested in the legislative process and committees and stuff like that? He says, no, I kind of find that boring. I said, well, maybe pick another class then. But some people love that, and that's a great course for them to take. So the court is sort of a, as my mother would call it, sexy. You need to meet my mother. Maybe I'll play her one of her, she sings to me when she calls my cell phone and she gets my voicemail. She makes up these little songs and sings to me. They're horrible, horrible. I mean, they're not vile, they're just, she can't sing for her life, so. But she likes to sing, she says, anyway. All right, secondly, we'll understand what the power of judicial review is. You had a chance, and we've had a chance to continually sort of visit and explore the Constitution. We'll look at Article 3 today, and we'll see that it's pretty short. Right? I mean, it's we could sit down and probably read that in 2 minutes at the most. And it doesn't mention this by name. We need to define what that is for you, but you'll note that once we define it, it's not there. Is that a problem? Well, maybe, maybe not. We have seen something called implied powers included within the executive branch. We went all the way back to Pacificus Helvidius, and that's essentially what Pacificus' view was that there is implied powers in the presidency. Now the question is, does the judicial branch have that as an implied power? So it's not stated specifically, can they still do it? We'll see how that argument goes. In order to do this, we'll just have to do an overview of judicial history. I'll just tell you a little story. We'll walk through it and give you some touch points in American history where you start to see the court kind of change. And as you'll see, the 14th Amendment changes everything. So we'll make sure we investigate the 14th Amendment quite a bit. All right, best place to start is to look at this power of judicial review. I will pull out my copy of the Constitution. If you have one, it's a good time to pull it out. And Article 3 doesn't say a lot specifically about what this judicial branch shall do. The most pertinent section is Section 1 and the first part of Section 2. It just reads pretty simply. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress from time to time may ordain and establish. So there's really only one court in the United States that is mentioned by name. Theoretically, the Congress today, could do away with every other court in the Union except the Supreme Court. Well, they'd have quite a workload, wouldn't they? So they have created a court system in which you have different levels of federal courts and different levels of state courts, and you have local municipal type courts. The one we'll talk about, that, as my mother would say, is most sexy and controversial is the Supreme Court. So we'll talk mostly about that. If you're interested in more of the judicial branch and you get interested in law, you'd want to be familiar with the different appellate levels and things of this nature. But for our purposes, we'll just mention the Supreme Court. So it says that there shall be a Supreme Court and any other courts that Congress established, and they've established quite a few. And then it says that these judges, both in the Supreme and in these inferior courts, shall hold their offices during good behavior, meaning that these guys are not subject to re-election or election in the first place. They're appointed by the president, and that doesn't mean they automatically get their job on the bench. They have to be what's called confirmed by the Senate. And that has become an increasingly nasty business. So that if a Supreme Court justice today dies or retires, President Obama will nominate another person to fill that seat, and it will be a nasty, nasty fight. And if you are nominated to the U.S. Supreme Court, you better put your seatbelt on and get ready, because you're going to be painted as a pretty nasty person. Yeah, you guys were too young to remember this, but the first African American appointed to the court by a Republican president back in the early 90s called his confirmation process a high-tech lynching. That's how nasty it got with that business. So you better be committed to the project before you submit yourself to that. So then Article 3 just basically goes on to say that the judicial power shall extend to hearing cases and controversies. And it sort of paints a picture of a pretty limited form of power. But again, if you were to read all of Section 2, which again wouldn't take us but a minute to read, you'll never read those words. The power of judicial review is actually a very simple idea. So let's make sure we get that to start with, because if you don't get this, you'll be lost for the next 2 hours. The power of judicial review is the power that the court argued that it had in a very famous court case called Marbury versus Madison. And I'll walk you through the soap opera that entailed here in a minute. But essentially the court argued that implicit or implied within Article 3 of the Constitution was this power. And this power is very simple. It's not simple to do, but it's simple to understand. It's the power to assess whether a law that is passed, so let's say this is a law, is in agreement with the Constitution. Pretty simple, right? And if they determine that this law is not in agreement with the Constitution, then of course we would throw the Constitution out the window, correct? Robert, yes?
Say that again? I was taking notes.
All right, that's all right. I saw you nodding your head, and I'm intrigued by this view, so I wanted to explore this a little more. If the court, in doing this power of judicial review, compares a law that a legislature has passed to the Constitution and find that the two are not in agreement, then the Constitution would be thrown out, right? Yeah, okay, good. That was a rather novel view that you held there. Of course, this would stay, and they would declare this to go, wouldn't they? Why? What's so special about this versus this piece of legislation? I mean, I'm just going to play the devil's advocate on this. This is passed by, a Congress in 2012. Isn't that more reflective of the people's will than this old crusty document that was done 200 some odd years ago? Apparently you all agree? No? What's so special about this? Nothing? Yeah? You no thoughts on this?
The Constitution was written by founders and just the foundation of our nation.
Now that's an interesting term, foundation. Sort of a baseline, isn't it? Now, of course, some people don't see this today. Here, let me just introduce you to a greater debate. There are a lot of people, including people who sit on the bench, that say it makes no difference what this document would have meant 200 years ago. It's unimportant. The meaning of this document, they say, and you'll see this here in a second, literally changes as the times change. I mean, that's one way to view this document, as sort of a living, breathing type document. So the question of assessing doing this power of judicial review in that light becomes really kind of weird, doesn't it? Because this is a moving target. So that's hard. Some people say, no, this document has an enduring foundational type meaning. That when we look at a contemporary piece of legislation that's passed and we compare it to this, if it's not an agreement, so much the worse for this. That's what's going on and what will be announced in a major landmark case this summer. So in June, when you're sitting around the beach and you're flipping through your fancy little devices that you call phones, and you see, wow, the Supreme Court ruled on Obamacare today. What did they rule? Essentially, that's what they're doing. They are looking at Obamacare and seeing if there's an agreement with an aspect of the Constitution called the Commerce Clause. And if they rule that it is not in agreement with it, Obamacare goes down the tubes and they start over. If they say it is in agreement with it, then it sort of has the judicial blessing and that it's still the law of the land. And then there's going to be a huge political fight this fall because the Republicans and Mitt Romney are going to say, well, then it's our first order of business to repeal this. Okay? See, this is the nature of the game. Okay? All right. So as I've already alluded to, in this process of comparing a law to the Constitution, which is the power of judicial review, it depends on your view on what this means. If you are a strict constructionist, you think this document has, think of your hermeneutics class, like, how do you read the Bible? Do you read the Bible as having some kind of enduring meaning? That what it would have meant to the readers or the writers of those books means the same thing across time, and it means the same thing to me? Well, if you believe that about the Bible, you might think the same thing about the Constitution and be a strict constructionist. And that's essentially the view that the Constitution has an enduring meaning and that it's important to discover, as Osnod has referred us to, it's important to discover what the founders intended in this document. Those are important questions for strict constructionists. That is not an important question for more what's called an activist approach, where you see this document as kind of an organic, living thing. It's like a warm piece of plastic that molds to the time. And I don't want to denigrate that view necessarily. You may sort of hear that view and go, that doesn't sound too good. But I will tell you that many people hold that view of the Constitution. About half the U.S. Supreme Court today holds that view of the Constitution. That it's moldable to the times. And all this kind of thinking is part and parcel of what I'm going to tell you this story as we go forward today. And this story is that the judges start to see their job differently. And they start to see that part of their role is to keep the Constitution up to date with the times. Do we have a mechanism in our Constitution that is supposed to keep the Constitution up to date? What's that process? The amendment process. So maybe one could argue that if the Constitution needs an update, then we have a process already to do that. The court has largely, by adopting this approach to the Constitution, sees itself as an amendment process without going through all that it takes to amend the Constitution. Here's what it takes to amend the Constitution. If you want to offer, we have 27 amendments to the Constitution. If you want to offer the 28th, you have to get both houses of Congress to pass that piece of legislation in 2/3 majorities. That's tough. Then you have to get the president to sign it. That could be a tough job if he's not on board with this. If that happens, then that potential amendment to the Constitution goes to the states to consider, and 2/3 of the states have to, in their state legislatures or what's called state conventions, ratifying conventions, have to give their blessing to that. If all that happens, then the Constitution is ratified. That process could take years. So maybe it's just easier in modern time if the court just does it for us. Some people argue that that's the way to go. Some people kind of go, I don't like the way that goes. There was a symposium offered in the late 1990s that some of my students who are doing research in this area in political science, there was a symposium in the late 1990s by a group of people who didn't like this, that said, look, that's not the constitutional order that we established, and we're living under a day and age what they called a judicial oligarchy, in which the judges are essentially ruling us. And they said that's not what we signed up for 200 some odd years ago, and they questioned whether we still owed allegiance to the American government as a result. Woo! That turned a few heads, big time. So if you're interested in that debate, I got lots for you to read. Okay, so again, this is an interesting question about how you view the Constitution. All right, we're going to look at the rest of the day these three periods of the court. I'll give you a second. This is a reasonably important slide just to acclimate you to where we're headed. There are three periods that judicial scholars look at the period of the courts, and they say that roughly from its instantiation in 1787 to about the end of the Civil War, the court was kind of not inactive, but they demonstrated a kind of reserve or limit to their power that by the time we get to the modern court, they no longer do. So they do something very different here in the modern court, and look at the dates, roughly, the mid-1930s to now, that they do now, but they didn't do here. Well, now, of course, like all processes, there's a transition, right? From this to this requires a transition. All I'll want you to see in this transition period is what is the hook that caused them to move from this to what we see today? And there's a subtle little hook here that I want you to see. And it largely revolves around the idea that justices see themselves as being able to do something different than they would have been able to do here. And it's a subtle little hook that moves them in a direction, okay? So we'll just walk through that the rest of the class. This is where we are today. So I really want to make sure you understand where the court is today on these things so that you can assess these, because my guess is that if you're not already impacted in some of your views by what the court has landed on, you will be in the future. If you think that Obamacare is the greatest thing since sliced bread, the court may overturn that in a month. So that's going to impact you, and vice versa. If you think Obamacare is horrible and the court upholds it, you're going to see. Okay. Everybody got enough of that one? No? All right. So here's the big story. During this period of time, the courts see the power of judicial review as being very limited, and they only invoke the power of judicial review to strike down laws during that period of time, almost pushing 100 years or better part of 80 years or so. In 80 years during this period of time, the U.S. Supreme Court struck down a grand total of 2 laws in 80 years. Sometimes they do 2 a day during this period. So what's happened? What has happened between the court during this time period versus this time period where they're much more, say, active in a certain regard? And many people see this activity that takes place right here as being unconstitutional. That we're no longer operating like we did back here, not only with the courts, but with other branches as well. Okay? So let's start walking through and help you understand this one, and we'll see if we can bow tie that before our break here. Okay. During that traditional, the era of the traditional court, the court had to establish itself on the constitutional playing field. Believe it or not, during the 1790s, the first U.S. Supreme Court justice, a guy named John Jay, literally resigned from the job Because he was bored. It's like he came to work every day, kicked his feet up on the desk, smoking a cigar, and thought, geez, Louise, there's nothing to do here. The court really gets into the game in 1803. And in 1803, there's this famous court case called Marbury versus Madison. And it's in that case in which the court argues that implied within Article 3 of the Constitution is this power, which I've been preaching on now, of judicial review. But the power of judicial review that the court argued for was limited by these three things. So let me walk through that. So again, during this traditional period, during this time is where we're talking about now, the court establishes itself on the constitutional playing field as possessing this power of judicial review, but it's going to be limited by these three things. Okay, again, the power of judicial review is the power to compare a piece of legislation to the Constitution. And if this is not in agreement with this, and that's sometimes a very hard thing to do, to compare them. Sometimes you think, well, this says A and this says B. Well, yeah. Sometimes judges go through a lot of work to determine whether it's in agreement with it or not, as they're doing now with Obamacare and certain provisions of it. This isn't an easy call, so they're having to wrestle with it, and we'll see how they come down on it next month. But that power to compare a law to the Constitution, this power of judicial review, argued the justice who wrote the Marbury versus Madison opinion, and his argument was essentially the same argument that came out of Federalist 78, which is what you had a chance to sort of at least be exposed to this week. The same argument that Justice Marshall makes in Marbury versus Madison is essentially the same argument that Alexander Hamilton made in Federalist 78. And the argument was this, that that the judicial branch will be the weakest of the three branches of government, largely because these people would not be possessive of the power to exert will, but only to judge. Now, here's the difference between willing and judging. Is there any question in your mind that our legislative bodies possess the power of will, where they can express their will on something? How do they do this? How does a legislative body express their will? This is one of those giant softball questions that I'm guessing you all know, but I'm trying to keep you alive and awake here, as I can tell that some of you need this right now. So how does a legislature express its will?
They vote.
Thank you very much. There it is. He just hit it out of the park, and he's rounding third, waving to all the ladies in the stands or on the field if it's a co-ed softball game, right? They vote. They vote yay or nay. That's an expression of will. I think this should be a law. I think it shouldn't be a law. That's what a legislative body does. The question is whether the court should do that. The initial go-around, way back when, said no, that they would only judge. So when they do this act, they're not saying that they would have voted yay or nay on this law because it's a bad law. They're just saying it's not in agreement. They're just judging whether it's in agreement with it or not. It might be a horrible law. It might lead to terrible ends, but they wouldn't throw it out based upon that. They would only throw it out based upon their judgment that it's not in agreement with this. We have a lot of bad laws on the books that are not unconstitutional. If they threw it out because if they announced to do a court opinion, they're just throwing it out because, man, that law just stinks. That would be an exertion of will, not judgment. Yes?
Wouldn't their judgment be biased on their
Okay, fair enough.
their views?
Huge question. And the answer that one is given if you want to grab your collar and look really intelligent is no, of course, that they divest themselves of their personal biases and judge based upon the law and the Constitution.
So we're still human.
There you go. Well, yes, and welcome to the giant fight over about the nature of judicial power. Yeah. Yes.
I think in some ways, when you were talking about the judge who voted against the Prop 8, being homosexual himself should have stepped out of the argument because he has a bias. That's his conviction, that's his lifestyle.
Maybe.
And so by voting that, he is putting forward a bias.
Yeah, and his claim was that he was able to successfully divest himself of sort of his personal life and his professional life as a judge. Okay, you're skeptical of such a claim, and you may be in a long line of people, but nevertheless, there's a long line of people who say that conservative judges on the court are not divested of their conservatism when they rule on things.
Yeah, nobody is, I would say.
Well, fair enough. Fair enough. Okay, so you're somewhat, and these are the same arguments that you're raising here that were raised 200 some odd years ago by people who were skeptical of the branch that we now call the judicial branch. These anti-federalists, I could show you material where they'd look at this and they raised the same issues you raised and said, these guys are going to be legislating from the bench. It's not going to be possible for these guys to divest themselves of their will and only have judgment. I'm just telling you, this is Hamilton's argument, where he said in Federalist 78 that they would just exert judgment and not exert their will, and that would make them the weakest of the three branches, or at least an element of that. So the claim was that when the court would strike down a law that they saw as not being in agreement with the Constitution, it wasn't an expression that the judicial branch was superior to the legislative branch. You know, because sometimes you think, well, gosh, you know, 5 guys on a court strike down a popular piece passed of legislation. Isn't this claiming that they're superior? The argument of Federalist 78, that as you read it over this past week, the claim is that when justices would do this, declare this unconstitutional and throw it out, is not to establish the judicial branch is superior, but just to make sure that this remains superior. So the court, at least so the argument goes in Federalist 78, argued that the role of the judiciary was to maintain the superiority of this document. They're sort of like the guardians of the Constitution, so that no temporary legislature would pass something that would violate this. You like that? Does that sound reasonable? You don't know? So the argument goes. Okay. Secondly, this power of judicial review was limited due to something like this. If, in doing the assessment about whether this is in agreement with this, if it was too hard for them to call, or they could sort of go either way on this, they gave the benefit of the doubt to the legislative, meaning that they assumed, first and foremost, that the legislative body was passing laws that were constitutional, and they had to be shown very clearly to be not in agreement with the Constitution before they would throw it out. That's why you read this word, manifest tenor. That's just fancy language for saying it has to be a clear violation of the Constitution in order for this to go. That's the second limitation. The third one is that if there was something involved in this comparison that involve discretionary acts of political people, like here's a great example. Let me tell you about a mythical court case. Let's say that there was a court case called Obama versus John Kerry. Now, John Kerry, if you recall, was the guy who ran for the presidency in 2004 against President Bush. He was the Democratic nominee. Now, when Obama became president, he nominated, and Hillary Clinton was confirmed as the Secretary of State. What if, upon that act, John Kerry said, that's bogus. I would be a better Secretary of State. I'm going to sue the President of the United States and argue that I was the better choice for Secretary of State. And so you have this mythical court case, Obama versus John Kerry. If that case ever made its way to a court, especially the Supreme Court would say, we're not going to hear this. Why? Because it involves a discretionary act on behalf of the president. That's his call. That's a political call. If he thinks Hillary's better than John Kerry, we're not involving ourselves in that. That's this. So if the case in front of the court involved a political question, the court just says, we're not hearing it. So when you combine all three of these limitations, you create a very limited form of judicial review. And again, in 80 years, the court strikes down 2 laws. So you can see that it was pretty limited, right? 2 in 80 years. All right. Now, let me tell you that this argument was made in Federalist 78, but it was also made in Marbury versus Madison. Now, some of these slides hint at the fact that at some point in this course's history, I used to have you read a section of Marbury versus Madison. I've ceased to do that because, it got a little technical and people kind of struggled through it and it wasn't particularly helpful. So let me just sort of tell you the little soap opera that you would have been able to discern in this particular case. So what are the basic facts of the case? When I teach constitutional law to my majors or anybody else who's interested in constitutional law, by the way, if you're interested in the law, and I mean, I've got journalism, I've got a biblical studies major in my class this semester, and they're all doing very well. But so if you're ever interested in constitutional law, there's a whole course devoted to that. It's a very demanding type course, so if you're going to join us, strap yourself in for a hard semester. We do 4 to 6 case briefs a week, so we'll do almost 50 case briefs over the course of the semester. So not to intimidate you, but it's once you get into it, they're kind of fun. And the reason they're kind of fun is because you have to remember that these court cases are not abstract things. They involve real live people who get hosed or think they get hosed. And so people sue, right? So Marbury versus Madison is a kind of fun little story. So if you can follow the bouncing ball here for a minute, let me tell you the story of how a poor guy named William Marbury got hosed. And he really did get hosed. He got kind of caught between one administration, the Adams administration, and the incoming Jefferson administration. And he got caught in the middle of it and essentially gets hosed. Here's how it goes. If you're going to be a justice in some federal court, the president has to nominate you and you have to be confirmed by the Senate. If you recall, way back when, Jefferson and Adams have this really contentious election in 1800, and Jefferson wins very narrowly. But it's the first time in American history where you've got an outgoing administration that thinks very differently from an incoming administration. First time in American history. If we have an election in 2012 and Mitt Romney is the president, it's very likely that Mitt Romney will govern the United States in a very different way and different direction than President Obama is currently doing today. Well, we sort of take that for granted. Okay, elections have consequences and we move, and it's not likely that Barack Obama is going to barricade himself in the White House and that some police force is going to have to come in and forcefully remove him. To the contrary, if President Obama is defeated, next January, he and his lovely wife are likely to put on very nice clothes, and when President-elect Romney on this January day comes to the White House, they'll greet each other, hug, and the wives will embrace, and they'll look pretty, and they'll take pictures together, and they'll ride in the same car up to the Capitol, and it'll all be wonderful. Well, we sort of take for granted these kinds of things. But what we don't see sometimes is people who get caught in the middle of these transitions. In 1800, a poor guy named William Marbury gets nominated by the president to be a federal judge, and he's confirmed by the Senate. And then there's certain paperwork that has to flow, right? It's called a commission. So, you get this, so the Senate says, yes, we think William Marbury ought to be on a federal court. He is nominated by the president. The Senate says yes. The paperwork starts to flow. Unfortunately, the paperwork doesn't get delivered to him. So this commission, an actual piece of paper, is signed, it's sealed, but it's not delivered. So on a Friday, the Adams administration is negligent on delivering this document to this guy so he gets his job on the federal bench. On Monday morning, the new administration comes in, and the incoming Secretary of State looks at this piece of paper and says, "Are you kidding me? I'm not giving this guy his paper. I don't want another Federalist type judge on the bench." And so he refuses to deliver this guy's commission. And so there's a question of whether he should get his job or not. That's the case of Marbury versus Madison. Guy gets hosed, right? I mean, the whole process was completed, and now he just gets caught between the shuffle of two different administrations. Yeah.
Was Madison a person that did
Yes. What really makes this interesting and soap opera-like is the outgoing Secretary of State is a guy named John Marshall. So John Marshall was the Secretary of State under the Adams administration. It would be like, you know, if Barack Obama loses in November, Hillary Clinton is now the Secretary of State. She'd be the outgoing Secretary of State, and the incoming Secretary of State was James Madison with the Jefferson administration. What if, in the interim between the time President Obama lost and President Romney takes office, President Obama nominates, and she is confirmed to the Supreme Court, Hillary Clinton? That's what happened in 1800. The outgoing Secretary of State, John Marshall, in the interim between administrations becomes the Chief Justice of the United States Supreme Court. Do you see how he might have a conflict of interest here? So a case comes before Chief Justice Marshall in 1803 involving something that he had something to do with, right, in the outgoing Adams administration, if you're following this little soap opera. So this Marbury guy sues and says, "I want my job. James Madison won't give me my piece of paper," and he wants his position. So the first half of this court case is whether this Marbury guy should get his job. And the answer to the general question in the first half of the case is yes. And he makes some kind of funky legal argument, not particularly funky, but you know, I mean, essentially it comes down to this. What if the commission was mailed to this guy and the mail service simply lost it? Would that make his commission any less official and legal? No, says Justice Marshall. So this guy is due his job, and somebody ought to order the president to do it. But here's the wrinkle with Marbury versus Madison. The United States Supreme Court, in that opinion, while at the same time ruling that somebody ought to order the president to do it, says we can't be the court to do it. And here's the little fun part. In this case, the court argues that it possesses this power of judicial review. It has to argue in this Marbury versus Madison case that it is the proper branch of government to make the call and do this comparison. So if you ever read a shortened version or even a long version of Marbury versus Madison, you'll see a part of that opinion in which Justice Marshall argues that we're the proper branch of government to sort of make this assessment. And without getting into all the fancy details, it essentially boils down to this. The court is, the reason Marbury versus Madison is such an important case is it's in that case where the court argues that it possesses a power, the power of judicial review, while at the same time divesting itself of a power, namely to rule in this particular case. And I won't get into all the funky details. If you're following it, it essentially comes down to this. There was a law passed in 1789 giving the court what's called original jurisdiction in certain kinds of cases. Original jurisdiction is the power to hear a court case for the first time. There's something also called appellate jurisdiction, is where you hear it's a case has already been heard and somebody doesn't like the way it came out, and so they appeal it. That's called appellate jurisdiction. In 1789, the Congress gave the court the power to hear something on original jurisdiction. The original Constitution only gave them appellate jurisdiction. If this is making any sense at all, it's okay if it's not. But just for those of you who are following this with your great legal minds. So now you have a conflict. You have a law that gave the court original jurisdiction, and this only gave it appellate jurisdiction. So they threw out the 1789 Act, or the portion of it, and kept this. So what they're doing is saying, this court can't hear this case because we're hearing it for the first time in original jurisdiction. So somebody ought to give this guy his writ. Unfortunately, it can't be this court. So the genius of Marbury versus Madison is that the court assumes for itself a power of judicial review while at the same time saying that they were powerless in this particular case. That's why Jefferson had to swallow it like castor oil. First half of the case, Thomas Jefferson was probably reading that with smoke coming out from under his collar because he was being told by a Federalist judge on the U.S. Supreme Court that he was acting improperly and not giving this Marbury guy his job. But by the end of the case, he has to just swallow it because at the end of the day, he's not told anything. And so this Marbury guy at the end of the day, he's hosed. He's not going to get his job. He better find another line of work. And he had to because he was not going to be a federal judge. Bummer, huh? I mean, you get fitted for your robes and you're ready to take your new position and you find out you got caught in the backwash of one administration to the next. So the enduring aspect of Marbury versus Madison, that you may just hear this at some point in discourse at some point, is that's the court case in which the court argued that it had the power of judicial review. So just so you heard the soap opera once, just so. Okay. Well, we just talked that. Now, we'll spend a few minutes introducing this to you before we take our break. So in 80 some odd years, the court only invokes the power of judicial review in a very limited sense. And then there's a period of transition, and you'll note that this follows right after the Civil War. And the reason that this is a period of transition is because the 14th Amendment is passed. After the Civil War, there's 3 amendments that are passed that are called the Civil War Amendments. I think I have a slide on this, but it's the 13th, 14th, and 15th. Do you recall what the 13th Amendment does? Frees the slaves. Why? Here's some good review. Why in the world would we need a 13th Amendment? Lincoln already freed the slaves with the Emancipation Proclamation, right? I mean, why go through the trouble of passing an amendment if Lincoln already accomplished this during the Civil War with the Emancipation Proclamation? Recall that little discussion? Worth reviewing. This will put something behind you so you don't have to study it or refresh yourself too much on this in a couple weeks. No?
Was it that the Emancipation Proclamation was only for certain states?
Uh-huh.
And that for other states they just couldn't hire, what is that? I don't remember exactly.
Okay, you're on it. Good.
Was it that they couldn't hire new slaves, but they could keep the ones that they previously had or something like that?
Mm-mm.
No?
The slaves that Lincoln freed via his executive order, which you and I have discussed as the Emancipation Proclamation, freed only those slaves that were behind Confederate lines. So if you look at the Emancipation Proclamation again, you'll notice that it has a paragraph listing the geographic area in which these slaves would be free. Lincoln freed the slaves behind Southern lines because what were those slaves doing behind Southern lines? Helping the Confederate military in various and sundry ways, albeit forced to help them, but helping them nonetheless. So when he freed them behind Southern lines, he was trying to, as a commander-in-chief, hamper his enemy's military forces. So the Emancipation Proclamation was an act Lincoln did in a time of war that otherwise would have been unconstitutional for him to do, but now he's doing it as a commander-in-chief in an active time of war. That's been a huge theme that you'll see that carries forward to this day, because it's likely that if President Obama does something controversial, the argument he will make, and he stands on a lot of constitutional history when he would make it, is that times of crisis and necessity call for him to do this. Here's an example. Is it legal for this country to send an unmanned drone over a foreign country and fire missiles at foreign nationals and even American citizens to kill them? Is that legal? Well, President Obama would argue yes. And by the way, so would his predecessor, President Bush. Why? Because we're at war. These people are trying to foment more 9/11s. And so that's the argument that he's making. No, well, there are certain legal groups that are saying that that's illegal, but they're in a minority. Most people, most Republicans, most Democrats hold that these kinds of things are constitutional because of the time. So the 13th Amendment has to come along and free slaves that weren't covered in the Emancipation Proclamation. So my home state of Missouri was fully conquered by the North by 1863. So those slaves would have continued being legal slaves until the 13th Amendment. 14th Amendment we'll look at. The 15th Amendment is really going to bother at least two different groups of people in this room in the coming weeks. We're going to hear about women's suffrage rights. And we're going to look at the 15th Amendment and go, wait a cotton picking minute, says the ladies. Black men get the right to vote after the Civil War, but what about women? Where are they? Wait 80 years, right, ladies? Bummer. All right. So those are the three Civil War amendments, but it's the 14th one that really gets interesting. Ah, look at this, just on cue. So these are the three Civil War amendments, but it's this one that we'll want to look at here as we go forward in the second half of class that really is the hook in which the court's power grows. Really today's class can be summarized in one sentence. How has the court's power grown over 200 some odd years? Again, some people say it's appropriate for modern times that the court is more powerful. Some people say it's not appropriate. I'll leave that for you to decide, you know, and maybe you're just first time exposed at this, so you're just sort of first time maybe even thinking about it. Of course, all three of these amendments are passed over the dead bodies of Southerners. None of these would have passed prior to the Civil War. These pass in the years following the Civil War because Southerners were ineligible to hold political office. If you took up arms against the United States, which included most of the South, you were politically ineligible to hold office. Many of them were politically ineligible to vote. So the people who would have represented the South in 1868 and 1870, even 1865, would have been people who were Northerners who went down to get elected to Southern positions. They were called carpetbaggers, if you recall that term. All right, so let's take a brief look at the 14th Amendment and see why it's controversial, and then we'll take a break. We've seen the 13th. You know, that's the freeing the slaves. The 14th Amendment is quite long, so let me break it down a little bit for you. It says all, now here's an interesting term. What is that? What is a person? Is that a human being? Are those two different things? Now that's a philosophical question, or actually what it's called is a metaphysical question. Metaphysics deals with the discipline of philosophy about the nature of reality. I'm not just up here waxing eloquently. The court has had to try to determine what that is. My con law class tomorrow will look at the famous Roe versus Wade case of 1973. And in that particular case, the United States Supreme Court looked at that word and said, what is that? And their conclusion was that they saw no prenatal application of that word. So what's going on here in a woman's body? This entity could not be classified as a person. So that entity got no protection that this might offer. That's why it's an important question of what conclusions we come to as a culture about that, or what the legal community determines to be a person. The 14th Amendment wasn't around during the Dred Scott case in the 1850s, but nevertheless, it's not an unimportant conclusion that the court came to in the 1850s that a black man was not a person, and only persons can file suit in federal court, so the case was essentially thrown out because of that reason. It'd be like you showing up to a court and saying, we're not going to hear your case, you're not a person. That's essentially part of the ruling of Dred Scott. in 1973, the court determined that a developing fetus, whatever you want to call it, was not a person. All right, so here we go. All persons who are born or naturalized in the United States and subject to our jurisdiction are citizens of the United States. So there's some aspect in which they're now given national citizenship rights. Prior to this, most of your rights and protections came from your state. The 14th Amendment elevates certain rights that used to be only state issues to federal issues. Why in the world would they want to do that? This is 1868. Why would Congress pass an amendment and the states ratify it to elevate rights and protections to the federal level and not just the state level? Think about that for a second. Why would they do that? What is there about the post-Civil War era where they would want to have a massive food fight to pass that?
Have to do with what we were just talking about with like the Emancipation Proclamation, how pretty much in different states a person was kind of a different thing.
Yeah, and I'm thinking about a certain category of people, citizens, who might need some federal protection beyond what their state would give them. Who am I thinking of? Sorry? Yes, former slaves. Do you want, if you're a former slave in Alabama, do you want your protections, your rights to be defined by and protected by your state? That's probably not a pretty good deal, right? Because even post-Civil War, if you're getting your rights and protections of your rights from your state and you're in Alabama, probably not a very good scene for you. So the 14th Amendment says you're a citizen of the United States, and then it follows up and it says no state shall pass anything, and we'll define this for you here in a second. No state shall essentially get in the way of those rights and protections that you have as a United States citizen. So the 14th Amendment essentially does this. It creates a new category of citizenry, and it says not only are you a citizen of your state, which most people prior to the Civil War would have identified themselves as a citizen of their state. That's where you got most of your rights and protections. The 14th Amendment says now you have national citizenship rights, and states can't pass any laws that impinge upon those. That's essentially what the 14th Amendment is. And if you're a former slave, new citizen, African-American citizen, that's awesome. Right? That's awesome. Yes?
So do all the states have the same laws then?
No. So a southern state may do something very different than a northern state might do, vis-a-vis the African-American new citizen question. And that's the topic for the second half of class. Okay? So it says here in the back half, no state shall make or enforce any law which shall abridge, get in the way, of the privileges and immunities of citizens of the United States. That's known as, hold on to your seat, the Privileges and Immunities Clause. Holy cow. Nor shall any state deprive any person of their life, liberty, or property without the due process of law. That's known as the Due Process Clause. This is highfalutin stuff, isn't it? Right? Nor shall any state deny any person within its jurisdiction the equal protection of the laws. That one's known as the Equal Protection Clause. We political science people really like to get in the highbrow, and we come up with unique labels for things like that. So there are three provisions of the 14th Amendment: the Privileges and Immunities Clause, the Due Process Clause, and that last one, the Equal Protection Clause. This one is where the food fight is over. This changes everything. And if you're in my con law class or court and public policy class, we spend a whole semester talking about how those words in this amendment have changed everything. At this level, you ought to just know the following fact, that the 14th Amendment and its passage is the hook in which the Supreme Court uses to change the constitutional order in a certain kind of way, and it essentially makes more things a federal issue and less things a state issue. That's sort of where we'll leave it at this particular point. Okay, how is the court system and the nature of judicial power changed as a result of the 14th Amendment? And the question is, because the court has used certain provisions of that amendment, most notably this, to expand its power. Now that may seem like a kind of an odd thing to kind of get your mind around, but we'll give you the basic story of that as we go forward. And well, we've seen the 15th. All right. So as you've seen, there are three what's called clauses or phrases to the 14th Amendment that are particularly important. And again, this middle one here is where all the food fight has begun and ended, or still goes on. Yes?
We have some vacuums.
You have some vacuums?
I'm joking.
Okay.
Like a vacuum
Oh yes, there you go. Encyclopedias. The old days when they used to sell encyclopedias door to door. Ooh, that's a long summer, isn't it? Oh, can you imagine? We don't answer our door. I mean, in this day and age, you just don't answer our door. Do you do that too? Do you answer your door? I mean, it depends on what your community is, but there's just too many weirdos. I mean, you just can't answer the door anymore. All right, so this one, as we'll see, is where the fur hits the fan, as it were. So why is this 14th Amendment so important? Let's reiterate a couple things that we've mentioned, but make sure we drive home to you. Once the 14th Amendment, the purpose, or the arguably one view of the 14th Amendment, what it's come to be understood at least today, is that the 14th Amendment was meant to elevate your rights and protections from not only the state level, but now to the federal level. That in a very real sense, that you now possessed national citizenship rights that the national government would protect you on. Before the 14th Amendment, again, your rights and protections were largely governed by your state. That in itself changes the constitutional nature of things. Things that were formerly only state questions now become, as your mom would say to you, don't make a federal case out of this. Remember that phrase? Like when you were being a little pill and your mom would say, look, this is a little issue. Don't make a federal case out of it. What she was saying to you was, look, this is a minor thing. This is down here. Don't elevate it to the federal issue. That's what the 14th Amendment does. Things that used to be down here at the state level are now elevated to the federal level. And if you're a former slave, that's a good deal for you. The question is, does it just impact former slaves, or does it impact all of us? You might be surprised here how that question was initially answered. Okay? This is really the main purpose for what we're looking at today. Okay, any questions about that? You all just a bundle of energy today, and it is that time of year where we're on fumes. She's not on fumes, man. She's cranking away on high octane fuel there. I don't get to eat. I mean, do you feel bad for me? Like Tuesday, Wednesday, and Thursday, I just don't eat. Like lunch. I'll eat at 7 in the morning, and then I'll get home tonight about 9, and I'll eat again. So if you want to stop by my philosophy class about 4:30 with that, we're stopping class. That looks pretty good. In fact, it's looking really good right now. So anyway, no, that's fine. That's fine. Okay. So let's look at why this thing has been so controversial, and think about it now in light of the first 30, 40 years after the Civil War. The court has to determine now cases where people sue under the provisions of the 14th Amendment. And I'm going to give you two different scenarios, and I'm going to ask you to determine how you think, if you were on the Supreme Court, how you would have ruled in those two particular cases. Okay? So here is the operative questions pertaining to the 14th Amendment. The first, and they generally fall into two general categories. Do you understand that amendment broadly or narrowly? Does it narrowly only apply to former slaves? Or is it doing something that applies to all of us? That's the broad aspect, okay? The first way to ask that question is this: does the 14th Amendment only apply to state action, or does it apply to individual action as well? So one way to look at this narrowly is to say, when the 14th Amendment says no state shall, is that to be understood literally? That a state acting as a state, that's the only thing we're interested in? Or are we interested in individual action as well? So let me give you an example of how this kind of scenario plays out. Let's say Riley owns a hotel or a restaurant, whatever, in Montgomery, Alabama, and it's 1870. And some African American former slaves come up to the front desk of her hotel or her restaurant, and they'd like to get service, a hotel room or dinner, whatever. Is it permissible for an individual owner of a restaurant to say, we don't serve your kind here? No? If Riley owned the hotel with her husband and said, we don't, sorry Riley to pick on you. Riley would never say this. I know her well and she would never say this, but just to pick on her. Is it a violation of those African Americans, former slaves, is it a violation of their 14th Amendment rights for her as an individual to say, we don't serve your kind here? In other words, are private acts of discrimination permissible under the 14th Amendment? Notice that the state of Alabama hasn't said that African Americans can't eat in certain restaurants or hotels or whatever. It's Riley and her husband. See the difference? If the state of Alabama passed a piece of legislation saying we can discriminate against African Americans, that's one issue. Well, what about private acts of discrimination? See how this would have played out after the Civil War? Do you think that in your vast knowledge of those years, decades following the Civil War, that such events would have happened to former slaves? You betcha, right? So now the giant question becomes, if we go back and look at this amendment, how literally do we take these words? No state shall make or enforce any law which shall get in the way of people's privileges and immunities, whatever that means. Or no state shall pass any law which violates or deprives people of their life, liberties. This seems to fall under that, doesn't it? Don't you have the liberty to show up to whatever restaurant you want to show up to? Can any state pass a law which gets in the way of your liberties in that sense? Well, the state of Alabama hasn't done anything in this case. It's just Riley and her husband. See the issue? So that's where we're headed here, is the 14th Amendment to be understood narrowly to apply only to state action, or broadly to include individual acts as well? And there's a famous court case in the 1870s called the Civil Rights cases, in which they take a bunch of these kinds of cases, lump them all under one roof, and it's called the Civil Rights cases, 1873 or 5, somewhere around there. And how do you think the U.S. Supreme Court ruled on those cases? Huh? Did they pass? Well, former slaves hired lawyers and sued and said, our 14th Amendment rights are being violated in this case. Riley and people like her are violating my 14th Amendment rights, and I'm suing in federal court for national protection of my new national citizenship rights.
Well, did they kind of ignore that and still have that?
No, the amendment's still there. The question is how the court is to understand that amendment. Do they understand it narrowly to apply only to state actions, maybe of discriminatory actions? Or how about individual acts of discrimination in this case? The court rules, sorry, go ahead. Narrowly. They say that unless and only if a state passes a piece of legislation that would discriminate or violate a citizen's 14th Amendment rights, only that would be a violation of the 14th Amendment. So Riley and her husband are free to do whatever they want. Not good days for African Americans during this time period, as you might imagine, because once word comes out that that's what the law means, and that's what the 14th Amendment means, now individual acts of discrimination pass constitutional muster. Yeah.
Not to like condone the actions of those private business owners, but if they were to interpret it broadly, wouldn't they also be infringing on the rights of the private business owners?
You bet.
In some respect, by forcing them to
Yes.
do something that they don't want to do.
Exactly. Sure they would. In the name of protecting civil liberties at the national level. Yes, exactly. So word gets out around the South that individual acts of discrimination are not going to be violations of law, and this sets in motion a certain system in place down South. I read something very interesting in graduate school years ago, where right after the Civil War, for the first 5, maybe 10 years after the Civil War, race relations, hard to believe. I need to do more reading on this to see if this is just an anomaly article or what, but it's a very interesting historical article talking about the fact that race relations post-Civil War down South were actually moving in a positive direction, meaning that the races were starting to intermingle, and that granted, everything wasn't peachy and rosy. I mean, we had a long history of slavery, but that we were moving in the right direction until the court started to move by ruling this. And then it started to move in a bad direction, moving toward what is known as the Jim Crow era in America. Jim Crow era was the given legal sanction to a segregated kind of society. And that's largely the latter half of the 19th century, all the way up through the 1960s to a certain extent, and even elements now. Yeah.
So do you think that if the court hadn't gotten involved, then like racial reconciliation would have happened earlier?
So this argument was in this historical article. It's hard to know, counterfactual, but maybe. Yeah. I mean that if the court in those particular cases had ruled as we thought, so that's why I throw these out to you now. Well, of course, they're not going to allow Riley and her husband to do that. They did. So word got around. Now here's the other kind of case that might come up. Does the 14th Amendment, is it to be interpreted narrowly, meaning does it give rights to all of us, new rights to all of us? Does it elevate me as a white man in 1875? Does it give me new protections and new national rights? Or does the 14th Amendment only apply narrowly to only give former slaves, now black citizens, new rights? And here's a court case that sort of exemplifies this question. Yeah.
Well, doesn't it say all persons?
Then you might think, good question. So you might think in that light that they would interpret it broadly. Yeah. And that's largely where they've come down to today. You might guess that the court didn't initially rule that way. And you think, what? Because yeah, a fair reading of that goes, wait a minute, it says all persons. But here's the case that came up. A bunch of butchers down in New Orleans, private butchers, most of them white. In fact, I think in this particular case, I'm thinking it's called the slaughterhouse cases, dealt with white butchers in New Orleans. And the New Orleans legislature passed a law, and the justification was for the law was for public health and safety. Here's what the butchers in town would do. The previous practice was that when you butchered an animal as a private butcher, you'd butcher your own animals, and you'd take the parts that you couldn't sell, you'd put them in a wheelbarrow, and you'd go down to the Mississippi River and you would dump them in there. Yeah. Okay? So is it an unreasonable piece of legislation that the state of Louisiana would pass a law saying the following? I know that's how we used to do it, but we are granting a monopoly to that sort of butchery, this big conglomerate butchery. So private butchers now have to no longer, they can't butcher their own stuff, carcasses, they have to take the carcasses now to this place and have them processed, and then the meat would be turned over to the private butchers, who in turn would sell it to the public. And that meat processing place would be able to dispose of the parts of the animal that aren't usable in a more sanitary way than just dumping it in the Mississippi River. Does that sound like an unreasonable piece of legislation? No? I mean, state legislatures are apt to do these kinds of things, pass legislation. Now, think economically now. What does this do? What does this do if you're a private butcher in New Orleans? Think economically. What does that do to you now? I'm sorry? They're butchering it for you now.
Well, it like doesn't give you any work to do anymore. It's like you're only selling.
Well, you're more in the retail as opposed to wholesale. But right, I mean, formerly I would go out back or in my shop and I would butcher this carcass and dispose of what I didn't want to and sell what I didn't want to.
Are they deciding what you can sell and can't sell?
No, that's relatively unchanged. I mean, it's relatively easy.
Well, it would decrease the profit that you're making, you spend more, and then you won't be making as much, and you probably would struggle a lot with the business.
Or maybe even go out of business because of it. Think there's a lawsuit going to entail with that? Yeah. So whereas formerly I could expend my own labor and butcher these carcasses and sell the meat, now I have to expend the extra money to transport what I have, these carcasses, and this butchery's not doing it for free. It's costing me. Cuts into the profits, or it may be presenting a situation where my business is no longer even viable. I'm suing, saying that law violates my 14th Amendment rights, and I'm a white guy. The court has to determine whether the 14th Amendment gains new protections for me as a white guy in addition to the African American folks, or whether it just applies to the African American folks. In that particular case, they say, this just applies to African American folks. No 14th Amendment rights have been violated for you white butchers, and so they're hosed. So it's very important sort of what the court is ruling in this particular case here. The only other case of pertinence here that you might want to think about in this general genre, and it's not particularly a 14th Amendment case, or it sort of is a case called Plessy v. Ferguson. Did anybody read that case here? You did that one, okay. Do you recall what that was sort of about?
Well, yeah, it was like, he felt like he was getting his 14th Amendment violated, but they said that it wasn't, it was different. It was like... Yeah,
what were the facts? What was going on here? Do you recall? That's all right. No, I'll just do it for the sake of time. It's a guy who... Exactly. So the state of Louisiana passes a law that says that if you're of the colored race, you have to get on the colored rail car, and everybody else can get on the white rail cars. And that was challenged as being violation of people's constitutional rights, or somewhere around the 14th Amendment, arguing that these separate facilities were not equal, and so it was some kind of violation. And the state of Louisiana was doing it. So it's no longer Riley and her husband doing something that could be potentially violating my 14th Amendment. So now we have the state of Louisiana passing a piece of legislation that says colored's over here and white's over here. The court in that particular case says that separate but equal is constitutional. So even by the late 1890s, cases that came before the court dealing with state action, not private action as in Riley and her husband's case, but state action in that case, separate but equal passes constitutional muster. And it's not until the 1950s that the court in another very famous case called Brown versus Board of Education says that separate but equal is not constitutional. So that intervening 50, 60-year period is most notably known as the Jim Crow era. So when Southern societies, and some not so Southern societies, got wind that they could set up segregated society, you know, so you'd have restaurants and you'd have whites only section, that was constitutional. Why? Because the Supreme Court said it was constitutional. And people acted, you know, based upon that. It's not uninteresting stuff, is it? And that's to our point over here early, that's a lot of power that these guys are possessing. Now, here's the hook, and here's to the point about why judicial power has grown so much since then. The court is started to, during this era, started to smuggle something in. It used to be that during the traditional era of the court, that there was a direct one-to-one comparison between a law and the Constitution. What you see in this era, during this transitional era, is the court starting to smuggle something in the middle between here and here. And the thing that they start to smuggle in the middle are what they call underlying principles that justices thought were implicit in this document.
No, it's not off. It's just going crazy.
It's going crazy.
Sorry, I had to stop you.
That's all right. Oh, you need
Grab
this.
Yeah. I'll let you grab it.
Yeah, that would, I might scream. I might.
Okay.
Have I hosed it by sitting on it? Maybe I should throw it in here.
Oh, that might have been it.
Might just be sitting on it.
Yeah, try to put it there.
Okay. Okay, so where were we? All right. So here's the hook, and here's I just wanted if you're in an upper division course on this someday, and maybe someday you will, I may convert you to political science major. It's a much more detailed story, but essentially all I want you to see here is what the court starts to do, and people on the court during this era, is they start to look at this document and they say, we understand this document to have certain underlying principles that as we try to interpret it, it includes the underlying principle of laissez-faire capitalism. What does laissez-faire mean in general? Any of you Frenchmen out there? What does laissez-faire mean?
I might be totally wrong, but isn't it when the government kind of just lets everything go?
Yes,
And
let it be.
flows?
Yes, it's essentially the rough translation is hands off. So laissez-faire capitalism implies that the government should be hands off and let the market sort of run as it should be. Now here's the really interesting thing. I don't see the words laissez-faire capitalism in here. So the activist judges of the day, and here's something to hold on to your seat for, were the conservatives. The activist judges today are largely seen as the liberal progressives on the court. There's 4 of them. They're seen as the activist judges today. 100 years ago, the activists on the court were the conservatives who saw things in the Constitution that their opponents claimed aren't there, like laissez-faire capitalism. And here's how that kind of thing came up. It's already coming up in this slaughterhouse case that I told you about with the butchers there. But here's another case in which it came up to try to flesh this out for you. There's a case in Illinois in the later part of the 19th century in which the state of Illinois passed a regulation, a state law, statute, that said that if you owned a grain elevator in the state of Illinois, you could only charge so much in terms of, dollar per cubic feet. So when farmers harvest their crops, they need some place to put it, right? And these grain elevators stored your crops. So when you drove up with your storage vehicle and said, I'd like to pay you to store this grain that I've just now harvested, the grain elevators would charge you, you know. So if you've got 100 cubic feet of grain, it would cost you so much money per cubic feet. Well, the state of Illinois passed a piece of legislation saying you can only charge this much. Is that laissez-faire capitalism? No, that's government intervention into the market system. If I could charge $50 a cubic foot, what right does the state of Illinois tell me I can only charge 40? Isn't that depriving me of something? If I'm a grain elevator operator, white, black, green, or otherwise, what's that depriving me? It's another softball question. Think economics. What's that depriving me? It's not depriving me of my self-esteem. It's not depriving me of whatever. What's it depriving me? Money. What's money? Starts with a P. It's a term you've seen here in the last couple slides. What's a generic way to describe money? Starts with a P. Property. Okay? Here's the hook. Those grain elevator operators said that that Illinois law, the state, is violating the Due Process Clause. Why? Because the state is depriving me, a person, of my property without due process of law. Whatever due process of law means. Okay? That's the kind of case that would come up in these case scenarios. The conservatives on the court said, you bet that's a violation of the 14th Amendment, because the 14th Amendment and the Constitution in general should be understood to include laissez-faire capitalist principles. So for our purposes, for our discussion today, the hook of the 14th Amendment is that in this question dealing with property, where is it? Here. The court came to understand that word as laden with laissez-faire capitalism. And the conservatives who didn't want government regulation of the time were the ones who saw things in the Constitution that are not there. Today, that same charge is made on behalf of the liberals. Starting in the 1960s, the liberals started finding things in the Constitution that the conservatives said, where's that? Like the right to privacy. Where's that in the Constitution? Well, there's a famous case in the 1960s where the liberals on the court found it. And I'll tell you, before we get out of here today, how they found it. You might giggle, but that's how they found it. Okay, so this raises the question between something that's a little bit highbrow, but I think you can get it. The hook that leads us now to the modern court, this last aspect of judicial history, the transition between the traditional limited form of judicial review to a very activist form of judicial review that we see today, is where the court starts to see itself, and the judges on the court start to see itself as possessing the power to incorporate what they understand to be underlying principles included in the Constitution. And the reason it's a ramp up of judicial power is because it's judges who determine what those underlying principles are. In this case, laissez-faire capitalism. That, my friends, is an exertion of will. When a judge sees himself, sorry ladies, there's no Supreme Court justice that is a female at this point. The first one is Sandra Day O'Connor in 1985. So long time till the ladies sit on the bench. But nevertheless, the reason that this is an exertion of will is because it's the judge or justice who determines what the underlying principle is that's implicit in this document. That's an exertion of will, and that's the fast train that eventually leads us to the modern court. I sense a question.
I was just thinking about the whole ruling on like private business and discrimination. And even though the amendment, like you were saying, contributed to, I guess, cohesion between the different races in the South, in some respect, like right after they were given their rights.
Okay.
So it's moving in a progressive way.
Yeah, it's moving probably. The way it's interpreted today is fostering cohesion between races.
Yeah, it started that shift in that
Yeah.
movement.
Yeah.
But then they had the ruling. They have rulings on those issues, and they make a decision, and that sets it back. So no matter what decision they made, I think it still is going to have a negative impact. So how are you supposed to make a decision then? If, like, thinking retrospectively,
Mm-hmm.
should you have just thrown the case out and disregarded it altogether, or do you still make a decision?
No, they got to rule. And the question is, when they rule, who does it impact? Does it impact just the litigants that stand before the bar? Or does it impact the whole country? We have largely moved in this country to answering that question in the latter sense.
Yeah.
Now, to your question about the specifics of the day, yeah, it's important what the court ruled because word got out that this is so no African American could now sue for private acts of discrimination because the court said as long as it's not a state that's doing it, fine. That's bad. And what's really interesting to read is a guy named Harlan who was on the court at this time, and he was what's called the lone dissenter. So he got outvoted 8-1. He was the lone voice. And when you read Justice Harlan in the late 19th century, in these two cases that I've cited for you, he reads like somebody who could write today. So he was a man before his times, as you might imagine. So he writes in the late 19th century. Are you kidding me? The 14th Amendment means what we think it means on a fair reading. No persons, that means everybody. Are you kidding me? This allows private act of discrimination? No, that's not, that doesn't. So it's, if you really want to read some interesting stuff, and if we could go back and slap this guy on the back, it'd be one guy we'd want to slap on the back and say, at least one guy got it right, you know. So the bottom line to that story is what you sort of wince at happening in the 19th century, eventually the court sees it right, correctly. I mean, in that Plessy case that Jennifer read, I'm not sure your shortened version read it, but one of the lines of legal argument in that case was that the 14th Amendment was never meant to equalize the races. Of course the black race will be inferior and the white race will be superior. The 14th Amendment never meant to remedy that. It just meant to do something else, he argued. Wow. You know, 1896 is when that case was done. All right, so it's this underlying principle thing that does something particularly interesting. And here's a little bit highbrow, but I think you can get this. And this is going to pertain to that grain elevator situation, so think about that. When I was in junior high school, this little munchkin-like guy who taught us, Mr. Myrick, wrote the due process of law on the board. He wrote those words, and he forced us to tell him what that meant. Now, we sort of responded like you respond to a lot of my questions. I'm not opening my mouth because whatever would come out surely can't be right, and I'm not going to display my ignorance or perceived ignorance to the crowd, so I'm not going to say anything, and that's what we did. Well, he didn't let us off the hook, and he forced us to try to understand. He kept telling us, you know what this means. You know what this means. And we were like, I have no clue, dude. I've never heard of the due process of law or the due process clause. So he kept looking at individual words. So he said, what does this mean? What is that word? What does it mean to be due something? Well, it means that you have a right to something that somebody has to give you. All right, fair enough. What does that word mean? Process. Well, it means it's some kind of like procedure, right? Some kind of hoops that somebody has to jump through. Now when you put the two together, it's some kind of process that you're due of law. What is that? So when you add all that together, it means that there's some process that you're due that the law is supposed to give you. That's what the due process of law means, and that's what you're looking at right there. The common understanding of the due process clause was procedural, that before you could be denied your life, liberty, or property, that a certain procedure, or in most cases some kind of judicial procedure, was to be accorded you before you could be deprived of your life, liberty, or property. Can the government deprive you of your life, liberty, or property today? Hello? You bet. If you commit a crime, you can go to jail. That affects your liberty, doesn't it? If you commit a certain kind of crime, they might even put you to death. That's depriving you not of your liberty, but your life. Can they do this willy-nilly? No. There's a certain judicial procedure that you're due. You have a right to an attorney, you have a right to be charged, told what you're charged with, you have a right to a jury trial, blah, 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 all that stuff, right? That's procedural due process. What you see happening, and this is a morph, and this is a little bit highbrow, so if this isn't resonating, don't worry about it, or wrestle with it with me a little bit. What you saw in that grain elevator case was that they started to move to a new understanding of the due process clause. And they started saying, look, instead of looking at due process of law and saying that the operative word was process, they started to say maybe the operative word of that phrase, due process of law, is law. Maybe there's something about the law itself that in some unfair or arbitrary way deprives you of your life, liberty, or property. So think about that in relation to those grain elevators. Illinois passes a law that I say arbitrarily and unfairly deprives me of money, property, and I sue based upon substantive due process claims. And if the court begins to understand the due process clause to include laissez-faire capitalism as underlying principle, then this becomes a live option for us. Okay? At first, the court starts to adopt this in an economic sense, dealing with property. In our day, the court has adopted substantive due process in a social sense. So instead of focusing on the property, depriving you of your life, liberty, or property without due process of law, they focus on what's called liberty interests. Here's how it comes up in our day. Can Texas pass a law prohibiting abortion in certain instances? No, says the court, because that violates a woman's substantive due process rights. That there's something about the law itself that unfairly deprives her of certain liberty interests. The liberty to have an abortion. Turn this thing off. Okay. This is the train that the court rides to ride in on. Who's to determine what is unfair and arbitrary? Not a legislative body, but a court. This is the massive hook that's today fully prevalent at the court, to where it is now not the weakest of the three branches of government, but some might argue the most virulent and strong in certain areas pertaining to law and public policy. Okay? So let me tell you that story. So let's move into the modern court, as I recall here. What has now happened is that under this traditional notion where there was a direct one-to-one comparison, now something's getting smuggled here in the middle. It starts in the economic realm where the court starts to understand the due process clause in a laissez-faire capitalist kind of way and say that any regulation that seems to violate that in some unfair, arbitrary way is not good regulation, and they throw it out. Today, they talk about general principles like this. Where should we be as a society today? Are we behind the times in America, particularly comparing ourselves to Western Europe? Yes, we're behind the times, and these old archaic laws need to be thrown out by the court to bring us up to modern times. That's roughly what the court's been doing since the late 1930s. They have been seeing themselves as the branch of government to bring our constitutional order and our society up to where they think it ought to be. And sometimes that's been for the better, and sometimes that's been for the worse. In the early 1950s, the court took it upon themselves to say, look, segregated society, nah, this is bad. We're going to take it upon ourselves to say that we can't do this, particularly in the area of education. And we all kind of cheer that one. But I could submit there's many areas in which the court has said things that you may not cheer. And maybe we can talk about those as we go forward here. But that's roughly the name of the game. Okay? So let's look at the modern court now and start to see a little bit of a story going on here. For the first part of the 19th century up till about the mid-1930s, the court holds strong against a changing kind of government. The government, at least theoretically, starts talking about being bigger and more involved in things that it hadn't been involved in the early part of the 20th century. By the time it gets to the 1930s and we have a Great Depression, FDR and the Democrats ride into town and they institute a legislative program that really starts to do things that governments hadn't, that our national government had never done before. And for the first 4 or 5 years of FDR's presidency, the court turns back and declares unconstitutional a lot of FDR and the Democrats' New Deal legislation, declaring it violating laissez-faire capitalist principles. And there's a couple court cases which I haven't listed. Here's what happened. This is a little soap opera. FDR and the Democrats are PO'd about this because they're working hard to get all this legislation passed. They think it's going to be the key to help us pull ourselves out of the Great Depression. And this court, mostly in what's called 5-4 decisions, narrow majority, 5 people say this, 4 people say that. These 5 stinking conservatives on the court are getting in the way of all this New Deal legislation. And so FDR starts going around town saying that he might like the number 13 better. It's called the court packing threat. At any time, Congress can change the number of members on the U.S. Supreme Court. It happens to be 9, and it's been 9 for most of our history. But in the mid-1930s, FDR and the Democrats start talking about the fact that they might like the number 13 better. What would that do to the math? Well, if you're getting outvoted 5-4, and it's not going your way, and you add 4 more to the court, it's likely that the new vote on similar type lawsuits would now go what? 8-5 in your favor. That's called the court packing threat. So the political branches, Congress and the presidency, looked at what the court was doing and striking down all this New Deal legislation and started threatening to pack the court with 4 progressive liberals who would vote with the administration and the Congress on these things. and the court caved like a house of cards. In these particular cases, who cares? You know, you don't have to, I'm just throwing them up there just so you see them one time in your life. But in this case and in NLRB, the court simultaneously announced that it was getting out of the economic regulation business. Anything that the new, more powerful federal government wanted to do in the area of economics, regulating commerce, things like that, the court was not going to second guess. And it announced in the 1930s that it was getting out of that business, and these two cases came to be known as the switch in time that saved 9. Meaning, one of these 5 conservatives saw the light and saw where this was going and changed his mind and joined the 4 that was in the minority previously, and now they became the majority. Essentially announcing, we're out of economics. Anything the new federal government wants to do in the area of commerce, it can do. Now let me fast forward to our day. Since 1937, the United States Supreme Court has not struck anything down that the federal government has done of significance. The giant question is, will they do so next month? That's the significance of what you and I will hear next month that the court announces. For the first time since the 1930s, the United States Supreme Court may actually declare a federal piece of legislation to be an overreach of federal economic power, commerce power. Wow. I mean, that's how big this thing is in our lifetime right now. That one will, the case that's going to be handed down next month, they'll be talking about 100 years from now. So strap on and we'll see how that goes. In a footnote, and be honest with me, when you're assigned some reading and there's a bunch of footnotes at the bottom, do you celebrate this fact? Are you saddened by this fact? Be honest with me. I know what she's going to answer. So you've been assigned 25 pages of reading, and you're sitting there trying to work through this reading, and you come to a page and half of it is footnotes. Are you cheering? You're cheering because why? Nobody reads the footnotes, right? In a footnote, the famous footnote 4 of a case, the court announced that it was getting out of the economic regulation business and getting into a new line of business, which brings us up to the current day. And that's the social regulation business. By the way, if you get to graduate school, here's the difference between an undergraduate, a master's, and a PhD. At the undergraduate level, you celebrate the fact that there are footnotes on a page and you pay no attention to them and you don't read them. At the graduate school level, at the master's level, not only do you notice them, but you notice how many are there and you don't read them. At the PhD level, you notice them, you're thankful for them because you want to read what that person read and they cited them. Don't let that scare you away, because by the time you get to a PhD level, if you do that someday, you're generally reading on things that are genuinely interesting to you and you'll want to read more. So that it sort of narrows. Right now you're studying on a shotgun, right? You're in a poli-sci class here and then you're leaving for an English class and you're taking a biology class. Shotgun. But graduate school can narrow your interest in that regard. So, all right. So the bottom line that I want you to see here is that the court has now, starting in the 1930s, and the real era of the modern court is a court that sees itself as an instrument of social reform. That if it sees legislation on the books and somebody challenges it as being sort of not up to date, the court will bring us up to date. That's an exertion of will. That's making public policy. And it brings us back to what we started with today. Some people see that and cheer and say that that's exactly what we need to do in modern times, because the legislatures will always be dragging behind these things and we need forward-thinking people on the court to bring us up to speed. So the court has asked whether capital punishment is permissible is that constitutional? Never mind that the Constitution explicitly says it is. There are people on the court today, they happen to be in a minority at this particular point, but they'll probably gain a majority, who will say that those provisions of the Constitution are unconstitutional because Western Europe does it differently, and so they cite foreign law to justify their argument. You will see in your lifetime, and feel free to giggle at this, you will see a court case in your lifetime, probably before you have children, my guess is, in which the Constitution will be challenged as unconstitutional. That's where we're headed. Why? Could be that the Constitution has vague references to religious stuff. And so that's a violation of the separation of church and state. There are people now openly suing to make it illegal to read the Declaration of Independence in public schools because it has godlike language in it. And that brings religion into the public square, which is a violation of the First. See how interesting these, I mean, this is why I'm in sort of this field, because I think religion's fairly important, I say facetiously. And it's really interesting to me and important, I think, for those of us who take an interest in politics and these kinds of things to say, I'm not so sure about that, and maybe fight that. And so that's First Amendment class if you're interested in that question. We do have a class that all of you may want to consider at some point. Your 30 units of Bible, you have to take one integration class. We offer a class in the political science, BBST 465, that's an integration class where we look at these grand issues in general about the intersection of religion and the public order, or church and state, you know, Christian citizenry, you know, those kinds of questions. So just to put maybe that on your radar for future semesters. All right, so let's finish this story now. What is the modern, who cares about Caroline products, right? What has the modern court done that has changed everything in this area of social arena? It starts in 1925, and they essentially did this. Don't get lost in the hurly-burly or the legal beagle stuff. They've essentially looked at this document and announced that some of the rights in this document are fundamental and some of them are just ordinary. That's a key distinction to make, and you'll see why here in a second. Now, if you read this document this afternoon again, would you ever read a list? The following are fundamental rights, the following are just ordinary rights. No. The court in 1925 simply announces that distinction, and what it's been doing for the last 80 years is announcing that more and more of these rights are of the fundamental category and not just ordinary. Is this just semantics? Is the court just sort of playing here with semantics? No. This has huge distinction. If a right is deemed fundamental, and think about how this would play into the amount of judicial power. I'm telling you a story of the rise of judicial power. This is the vehicle in which the modern court has ridden judicial power to a whole new level. Simply announcing this distinction is a huge way towards doing that. But if a right is deemed fundamental, they are presenting to the legislature a really high hurdle. Any of you on the track team? All right, I'm not on the track team either. So let's say we all had to go out and do track this afternoon, and the track coach is out there and he says, okay, so for your training, the first order of business will be hurdles. You have to run around the track and jump over these things. Do you want to jump over the low hurdles or the high hurdles? And we all say, low hurdles. Why? Here's another softball question. Why would I want to jump over the low hurdles and not the high hurdles? Because it's easier. The court has presented a high hurdle to the legislature and a low hurdle. And here's the question. The court now sits in judgment of the legislature and says, We will only leave laws on the books as constitutional if the legislature can clear a very high hurdle. What hurdle is that? They have to demonstrate to us that they have a really, really compelling reason for the law in question here. They have to demonstrate to us as the court. The court sits in judgment of the legislature and says, you have to demonstrate to us that you have a really good reason for putting that on the books. And we're going to look at that law and your reason really, really closely. It's called strict scrutiny. And as we look at it really closely, we are going to try to determine whether you clear that high hurdle. And if you don't, then we're going to declare that law unconstitutional because we see that that law might threaten a fundamental right. This is the low hurdles. If the court leaves a right down in the ordinary column, it'll look at the law, sort of, we'll kind of look at it, but not like that. And if the legislature can give us even a reasonable standard for why they did that law, we'll leave it on the books. Do you see now how this sets an era of judicial supremacy? This is wholly different than what we started an hour and a half ago. An hour and a half ago, I presented to you a picture of the legislature being supreme, or at least having the benefit of the doubt. Now the benefit of the doubt is the laws they pass, particularly if they possibly impinge upon what we call fundamental, or what the court calls fundamental, as being arguably unconstitutional unless they can show really good reason why they might impinge upon that. Here's another way to play out this distinction between this and this. I got a 17-year-old boy who's not driving yet. I wish he'd get off the ball and do this, but nevertheless, he's not interested in driving. I think the freeways make him nervous. Let's say he does get his driver's license and he comes to me one rainy Friday night and he says to me, "Dad, can I have the car keys?" Rainy, it's Friday night, he's just been driving a few weeks. As he answers the following question, how closely am I going to be listening to his answer? I'm going to say, "Jacob, why?" How closely am I listening to what comes across his lips? Really close. What standard does he have to clear before I hand him the car keys? A really compelling reason. What if he says, "I want to go joyriding with my friends"? Doesn't meet that hurdle. I strike down his request. That's what the court does today. It has elevated things to this standard. They look at the legislature's reasonings really, really closely, and unless they can give the court a really, really good reason, they strike down laws. So they have been taking rights within the Constitution, elevating to this fundamental category, and striking them down. Take, for example, you may celebrate or you may lament this, there are many, many laws on the books criminalizing homosexual sodomy. Don't want to get into the specifics of that. If you know what that is, fair enough, right? The court has declared that those laws are now unconstitutional. Why? Because they have created schemas, and again, you may celebrate or lament this, I'm just sort of telling you the way it is. In the late 1990s, they deemed that right to participate in that activity as being a part of this category, and they could find no compelling reason why a state should impinge upon that fundamental right, and therefore they declared laws that have been on the books for 150 years or more unconstitutional for that reason. Now, again, you might say, perfectly reasonable, I think I celebrate that, or you may think, how in the world can they do this? Here's the question I just want to invite you to consider that we started this whole thing with. Is that the role of judges in society? If we think that those laws, those anti-sodomy laws, or whatever laws you want to put in here, are bogus and outdated, then elect people who will change those laws. Isn't that how it's supposed to work? Some people ask. Some people say, yeah, that's how it's supposed to work, but those legislative bodies are never going to be up to speed. And we need the court, who's more foreseeing in things and can make it happen quicker, do it for us. The court today is doing it for us. And some people on the Supreme Court give speeches at law schools announcing that that's what they do, and they don't get red in the cheeks when they do it. You know, that's the lay of the land in this deal. Largely, what has happened since the late 1930s is the court has embarked upon this social engineering. That could be understood negatively, of course, and it could be understood positively. In this case, the court did some social engineering and said, separate but equal in educational settings? No. And we look at that case in 1954 and we say, hip, hip, hooray, right? The court, when you read behind the scenes, I've done some reading in the justices who wrote in this famous 1954 case. One of the reasons that they ruled the way they did is they said these legislative bodies are never going to get up to speed on this segregation issue. They're going to drag their feet on this, so we got to get out ahead. The interesting thing about Brown is that they didn't ground the decision in the Constitution. That's kind of a problem. That's the most notable thing about Brown versus Board of Education, is that people celebrate it the way the decision went. Most people did. Southerners weren't happy about it, of course. Most people celebrated the fact that the court had ruled as unconstitutional these separate educational facilities. But if you read the case, you'll notice that they don't cite the Constitution. They cite social science. And that's interesting, isn't it? So here's the social science that they cite. When black school children are presented in sociological tests, white paper dolls and black paper dolls, when they look at the white paper dolls, they feel inferior. Therefore, separate educational facilities are unconstitutional. Yeah, it's a bit of a, okay. I mean, I guess it's an open question that if black school children in these sociological tests had been shown white paper dolls and they felt superior, then maybe segregated educational facilities were constitutional, you know? But anyway, just to sort of give you insight into the court, this is where the court has seen itself, and the country and the legal community has largely seen itself where the court or the judiciary has become untied from the Constitution, unmoored. They're no longer bound, starting in the 1950s, to ground their decisions based upon the Constitution. And now almost anything goes. And I'll tell you one last story and we'll be out of here. In the 1960s, the court starts to add more and more things under that fundamental right category. And in this case, they simply invent the right to privacy. My class, con law class, just yesterday looked at this particular case, and it's really interesting. I don't say anything to them before they read it, but they read this case and then they come in and we talk about it the next class period. And in 3 of the 4 opinions, there's a majority opinion and some concurring opinions, the justices in those cases simply invent the right to privacy. The majority opinion in that case finds the right to privacy in the following story. And you can log this under they're making it up as they go. Justice Douglas in that case writes the majority opinion. He says, is there a right to privacy in the Constitution? Answer, yes. How does he discover it? He uses the word emanations and penumbras in the legal thing, and you're thinking, what in the world is that? Emanations are like light. Light is emanating, right, from our bulb here. Penumbras are shadows. And Justice Douglas invites us to consider this as he discovers the right to privacy. As we shine the light of truth upon the Constitution, certain shadows are created behind it. So if I had like a flashlight, and here's the Constitution, and I shine the flashlight on the Constitution, back on the floor there would be shadows. And Justice Douglas says that we discover new rights in the shadows. The right to privacy. In 1965, what was included under the right to privacy was married women getting contraception. That was the practice that they included in 1965. By 1973, what was included in the right to privacy was abortion. By the 1980s and 90s, now the court is wrestling with, is homosexual sodomy a practice that we include under the right to privacy? How about the right to die? That one the court heard and for some strange reason said no. That inclusive in the right to privacy is not the right to die. Interesting. It just didn't seem to follow from sort of the progression of things that they were arguing. So that's sort of the modern court. And that as we bring ourselves into the last thing that I want to introduce you to, and this is why the 14th Amendment is so key. The incorporation doctrine is another court-invented doctrine in which they simply announce this. And again, they do it in the 1920s. They announce that the Bill of Rights means something different today. The Bill of Rights used to be understood as being limitations on the federal government. I mean, you look at the First Amendment. Congress shall make no law respecting an establishment of religion. Congress. That's those boys over there in D.C., right? It said nothing. It provided no limitations on the states. If the state wanted to establish a religion of the state of whatever, they're free to do it. That First Amendment did not apply to state action. The court announces in the 1920s that the 14th Amendment and its due process clause changes that, and that the Bill of Rights now also apply against the states. So things that used to not be a federal question now become a federal question. Again, this is a court-invented doctrine, and I throw out some court cases to you where the court sort of does this. That's not important for your purposes. But this is not a legislative body doing this. This is a judicial body doing this. So the bottom line here is that what we have today as judicial power looks very different than 200 some odd years ago. And again, some people celebrate that, some people don't. But that's the lay of the land that we find ourselves in. And so I'll end our time sort of alluding back to Lincoln's quote from his first inaugural address. Lincoln was of the opinion that if we ever allowed the court to speak for the nation about what social policy ought to be in this country, in his day it was slavery, in our day it's abortion or homosexuality, right to die, capital punishment, whatever. If we allow the court to set public policy, then we have resigned our liberties and that we've literally given them up to, as President Obama alluded to, an unelected group of judges. Now, the reason Obama's comments were so controversial is because the power of judicial review, the court claimed back in 1803, and they've been in that business since then. That's not particularly controversial anymore. What was controversial was for Obama to essentially say that Marbury versus Madison was not good con law. He backed away from that in the days to follow, but that was sort of his initial push-off.
Biola University offers a variety of biblically centered degree programs, ranging from business to ministry to the arts and sciences. Visit biola.edu to find out how Biola could make a difference in your life.